Dear students, I am Dr. Manish Singh. I am from Dr. Ram Manohar Lohia, National Law University, Lucknow. I will be discussing a module on qualitative and doctrinal methods in research. The probable learning outcomes of this module are to make you understand the contemporary debate surrounding the qualitative and doctrinal methods of research, to make you understand the meaning and concept of qualitative research, to let you understand the meaning and concept of doctrinal method of research, to encapsulate the methods of conducting doctrinal and qualitative research, to discuss the broad aims and objectives of qualitative and doctrinal methods of research. It also helps you to comprehend the advantages and limitations of qualitative and doctrinal method of research, to also help you understand the distinguishing factors between qualitative and doctrinal methods of research. In this module, we shall discuss the following areas: contemporary discussion on qualitative and doctrinal methods of conducting research. What is doctrinal legal research? Doctrinal method. What is qualitative research? Common elements in every qualitative research and the distinguishing factors. Aims and objectives of qualitative and doctrinal method of research. Basic tools of qualitative and doctrinal research. Advantages and limitations of qualitative and doctrinal methods of research, and finally the summary of what we have learned so far. A brief short introduction to qualitative or doctrinal research debate would be fit to locate both of them and analyze them with respect to their positives and shortcomings. Bryman had identified some 11 ways to integrate these two types of researches. According to Bryman, the logic of triangulation means to check for examples of qualitative against doctrinal research. The qualitative research outcome can support doctrinal method and vice versa. Both are combined in to provide a more general pictures of the issue under study. Structural features are analyzed with doctrinal methods and processual aspects with qualitative approaches. The perspective of the researcher derives the quantitative approaches, while qualitative research emphasizes the viewpoint of the subjective. According to Bryman, the problem of generality can be solved for qualitative research by adding doctrinal findings, whereas qualitative findings may facilitate the interpretation of relationship between variables in data sets. The relationship between micro and macro levels in a substantial area can be clarified by combining the two researches, which can be appropriate in different stages of the research process. Finally, there are hybrid forms that use qualitative research and quasi-experimental designs. The doctrinal legal research can be defined as research into legal doctrines through analysis of statutory provisions and cases by the application of reasoning. The emphasis is upon analysis of legal rules, principles or doctrines, as compared to non-doctrinal legal research, which aims at research on the relationship of law with society, groups and people. It involves an empirical inquiry into the operation of law, how the doctrine or principle which has been adopted in real world settings. Thus, the doctrinal legal research emphasizes upon research in law focusing. Thus, the doctrinal legal research emphasizes upon the research in law focusing on the black letters of the law. The non-doctrinal research focuses on research about law. Here the researcher is interested in knowing about the law in action. The former can be understood as armchair research, or basic or fundamental research. The later is empirical research. The doctrinal method begins by taking up a proposition as a starting point of focus. He then locates the law in statutes, judicial pronouncements, and discussions in commentaries, textbooks, journals, and debates, reads them in a holistic manner, analyzes them, and writes his findings. For example, a research on proposition of prevention against double jeopardy under criminal law would begin with locating the law in Constitution and criminal law materials. On the basis of the analysis of the same, the researcher may advance the set of formulations or may also highlight the objective behind the proposition and may propose what it ought to be. On the other hand, qualitative research developed as an alternative to quantitative research. It has grown from simply not being quantitative research. It has gained multiple dimensions now, which can be understood from the general understanding that this research focuses at the real world in order to understand, describe, and explain social phenomena from the inside in multiple ways. It is done by analyzing experiences of individuals or groups, by analyzing interactions and communications, or by analyzing documents. However, the common element is that it seeks to identify how people view the world, what they are doing, or what is happening to them in terms which are meaningful and offer rich insights. There are certain common elements in every qualitative research. They are that every qualitative research, is it methodological, theoretical, epistemological, has certain common elements which can be broadly identified as below. Experiences, interactions, and documents are analyzed in their natural context. Concepts and hypotheses are developed and refined in the process of research. It starts from the idea that theory and method should be appropriate to what is studied. They can be adapted if they do not fit in. Researchers themselves are also an important part of the research process, either due to their own personal experiences or research experiences. It takes cases and context seriously. A major part is dependent on text and documents. Thus, issues of transcribing complex social situations into texts is one of the major concerns of qualitative research. Experiences, interactions, and documents are analyzed in their natural context. Concepts and hypotheses are developed and refined in the process of research. It starts from the idea that theory and method should be appropriate to what is studied. They can be adapted if they do not fit in. Researchers themselves are also an important part of the research process, either due to their own personal experiences or research experiences. It takes cases and context seriously. A major part is dependent on text and documents. Thus, issues of transcribing complex social situations into text is one of the major concerns of qualitative research. There are certain distinguishing factors between qualitative and doctrinal methods. The qualitative legal research is different from doctrinal legal research on many grounds. Some of them are: it lays down a different emphasis upon legal doctrines and concepts. While the emphasis of doctrinal is purely basic and fundamental in exposing the law as it exists, the latter look at it from the perspective of social reality. Qualitative research seeks to answer broader issues as clear from the aims and objectives as would be discussed below. The doctrinal research has a focus on a particular point of law. It does not focus exclusively on case reports and other traditional primary and secondary legal documents for analysis. However, It is dependent on doctrinal methods in the sense that without a thorough grasp on fundamentals, the qualitative researcher would not be able to chart his voyage in a meaningful manner. It takes a different route for research, which has in focus to analyze law in action as distinguished from law in books. The qualitative and doctrinal methods have different aim and objectives. While the former is about finding and analyzing the legal concepts and doctrines, like for example the principle of strict liability under law of torts, the latter is concerned with law in action, that is, as to analyze the legal idealism from the lens of social reality. Each has its own utility and uniqueness and are interdependent on each other. To discuss the aims and objectives of doctrinal research. Doctrinal research helps to find the law in the legal statutes, subordinate legislations, and judicial precedents. It aims at consistency and certainty of law. To some extent, it looks into the purpose and policy of law that exists. Doctrinal research also aims to study legal institutions like courts, police, machinery, jail, tribunals, etc. Discussing the aims and objectives of qualitative research. A qualitative research focuses on the social facets of the law. Its primary aim is to determine through empirical data how law and legal institutions affect or mold human attitudes and what is their impact on the society they create. The researcher primarily looks into how far the law and legal institutions are serving the need of the society. Are they suited in the social context in which they operate? It determines the forces that shapes, reshapes, and mold the law. It is helpful in analyzing how far the law has been enforced and administered. It discusses the causes for the factors responsible for the poor performance of the law. It also looks into the factors which molds the enforcement machinery, attitudes, and behavior while interpreting and enforcing the law. Are beneficiaries under the law using it, or the law is merely symbolic? Whether the targeted beneficiaries are benefiting out of the law. If the law is failing to help people, where does the problem lie? Impact of law on behavior and attitude of society, people and groups are also determined by this method. Every research has its own specific tools and methods. Research instruments are the tools in the hands of the researcher to conduct the research. Proper tools ensure a well-planned and systematic inquiry. The researcher shall aim at developing procedures which are reliable and valid. By being reliable, it is meant that there is consistency of a measure, while being valid means to which the measure achieves its aims. They can be classified into primary and secondary sources. Let us have a look into the tools of these two types of researches. First, we shall discuss the basic tools of qualitative research. There are several ways of collecting data for qualitative research. The primary sources are interview, questionnaire, schedule, interview guide, and observation. It can be collected from either posing selected respondents to a set of predetermined questions or sketchy questions. It involves a face-to-face conversation, and this tool of data collection is known as interviewing. The predetermined questions can also be mailed, sent by post, fax, or other ways in order to gather responses from selected respondents. This tool of data collection is known as data collection by way of questionnaires. The researcher can also collect data by the method of observation, a systematic observation of a phenomena, behavior of participants, respondents, or institutions. The secondary sources are the published or unpublished reports, for example, crime reports, The secondary sources are the published or unpublished reports, for example, crime records, reports of international organizations, etc. A general understanding of tools like interview, questionnaire, schedule, interview guide, and observation would be useful. Interview is the verbal technique of data collection. It may be structured or unstructured. It is structured when the researcher uses a set of predetermined questions and highly standardized technique of recording responses. It is unstructured when there is flexibility in the approach to the questioning and much lesser standardization. It is unstructured when there is flexibility in the approach to the questioning and much lesser standardized way of recording the responses. The strength of this tool is that it remains to be the most effective method of gaining information about respondents' perception and opinions. It also enables the researcher to authenticate the information coming from the respondents by observing the body language of the respondent. However, administering an interview is an art. One needs to have the required skill set in order to conduct a meaningful interview. Undoubtedly, being most effective, it has its limitations, like memory bias, inability of the respondents to provide every information asked for, and bias. Questionnaire. In questionnaire, a number of typed or printed predetermined questions are used for collecting data. It is sent to the respondents with a request to send it back to the researcher after filing the responses. It may also be structured or unstructured. The questions may be open-ended, close-ended, mixed, or pictorial. The method can be very effective in circumstances where the respondents are scattered in a vast area. It is quicker and cheaper as compared to interviews. Schedule is more or less same as the questionnaire, but the major differences are that schedule is referred to form filled in by the interviewer during his personal interview with the respondents, and questionnaire, being impersonal, is rigid. The schedule is flexible because it gives the opportunity to the researcher to clarify the questions if they are not clear to the respondents. Interview guide. It contains only the topics or broad headings upon which the respondents are asked to answer. Usually, the questions are formulated on the spot and the responses are thereby recorded. Observation is a visual method of data collection. It is another specific way of data collection. It is another scientific way of data collection when planned in a systematic manner and recorded systematically, and is subject to check and control on validity and reliability. There are certain basic tools of doctrinal research. Statutory materials, subordinate legal materials, and case laws constitute the primary sources, while the secondary sources the researcher refers to are the textbooks, legal articles, parliamentary debates, etc. For example, if someone has to undertake a study on the principles of compulsory licensing under the law of patents, then the relevant provisions of the Patent Acts 1970, international instruments pertaining to compulsory licensing, law on compulsory licensing in different jurisdictions, findings of the court, and intellectual property appellate board, like in the matter of application for compulsory license by NATCO Corporation in Company Law Advisor 1, constitutes primary sources. While the commentaries on the provision pertain to compulsory license in standard textbooks, commentaries, articles in law journals, news reports, blogs, etc. would constitute secondary sources. So what are the advantages of doctrinal method? Doctrinal method provides quick answers to the practical problem at hand by analyzing the legal principles, concepts and doctrines, thereby serving as a ready reference to people who didn't have a time at their disposal to understand that research by themselves. Because, comparatively speaking, a doctrinal research requires less time. So thereby it ensures a constant stream of information on a regular basis. Doctrinal method gives insights into the evolution and development of the law. For example, consumer protection law. It offers a logical explanation to the law and at the same time also highlights inconsistencies and uncertainties in the law. It reveals gaps, ambiguities and inconsistencies in the law, thus informs us as to how law can be more purposive and effective. It lays down a roadmap to develop the law by avoiding the pitfalls. It helps in increasing the legal knowledge base. Future direction of the law can be predicted on the basis of such studies. It provides a sound basis of non-doctrinal research, because in deficit of the required preliminary knowledge, the venture of non-doctrinal research would be directionless and therefore futile. But there are certain limitations of doctrinal method. The first limitation is that it can be subjective and suffer from the vice of perception of the researcher about the required subject matter. Therefore, another person can reach upon an entirely different dimension to the same question. Further, it is devoid of any support from social facts. Therefore, his projection might be far off the social reality. This is a serious concern, as law can act as an instrument of social transformation. It neglects the factors that lie outside the strict brackets of law, which might have a bearing upon the legal principle, theory or doctrine. For example, the recent amendment in the criminal law regarding rape, wherein a huge public outcry was an extra legal factor that shaped the law. The actual practice and attitudes of people who are the functionaries and those who implement the law is also not taken into account. For example, the attitude of judges, lawyers, police, administrative authorities, courts and tribunals, etc. The qualitative research has following merits. It highlights the gaps between goals and social reality. It depicts a true picture of law in action. It highlights the gaps in relation to practice of law, enforcement agencies, and as well as in the use and underuse of the law by the beneficiaries of the law. It highlights the reasons behind failure of a law in real world. It may be inactiveness or lack of willingness on the part of those entrusted with the task of enforcing the law, or may be resistance on the part of intended beneficiaries for multifarious reasons like unawareness, fear of further victimization, huge costs in the terms of time and money. It thus exposes the weakness in the operation of law. In the modern welfare state, law acts as a tool of social and economic transformation. The qualitative research can bring forward the role and contribution of law in bringing about desired changes. It also can highlight the gaps that have been left in the law and social reality so that law can be reassessed in the light of new information. It serves as a significant resource in the form of a social feedback to policy framers, legislators and judiciary so that they can better enforce, legislate and interpret the law. It shapes social legislations in tune with the social engineering doctrine of the modern state. But there are certain limitations of qualitative research also. Qualitative research is extremely time consuming and also very costly. The researcher in this research has to build upon the bedrock of doctrinal research. He must be through with the doctrines and concepts, otherwise his research endeavor would be futile. The primary tools of data collection, namely interviews, questionnaires, and observation, requires a specialized skill set right from the stage of planning to the execution. Now, let us recapitulate what we have learned so far. From the above analysis, it can be understood that qualitative research arose primarily as a critique of doctrinal research. It was felt that the research outcomes were inadequate and incomplete in absence of an analysis done in real-world settings. Nevertheless, both research methods had their own merits and shortcomings, but it can safely be concluded that both informs the law and policy and are interdependent on each other. Thank you.